Good morning, friends. Sat Sri Akal, Adab. Well, I think I'm on my somewhat present last video on old grant. This is the third type of old grant. Now, this is the grant which was on government land. Cantonment authorities were also given were permitted to allot a specific dimension of plot to the Britisher or the British officer of the very posted cantonment he was. These notification of lands were merely occupied, but they failed acquisition because the British officer was not willing to acquire these grants. And neither was he willing to build on these grants because he knew he'll get transferred from the cantonment which he is being. So, let's say a grant of a specific size was given to Mr. A officer. Now, whether that grant was originally acquired or resumed from the old grant holder who was a revenue free grant, and whether that old grantee was compensated through the Cantonment Fund. This is all happening after 1864 because then the Cantonment Act came. Earlier it was barely the Governor General orders or the army regulations. Now let's say that officer posted in that very cantonment even retires within that cantonment. So is he willing to buy out that grant? Because since he is retired and he is in occupation. So these were some questions which were to be discussed of these government grants given by the cantonment officer. So I have already explained you that Satluj or the Punjab was never a territory, it was a non-regulation territory. So lands were never acquired, acquisitions failed within these cantonments as written in the Imperial Gazetteer because lands were becoming pride and the occupier or the tillers were not willing to part with their annual income, even if they were subjected to a lagan. Because somewhere I was reading a book on revenue, the British officer has been defined in a court of law that he is only looking for a lagan either to 1 acre or 1 anna, or would be 1 rupee, or maybe 1 biga is moreover to a anna or a rupee. So these compensations which were supposed to be given to the original grantee, were these compensations in perpetuity, that till the government is an occupier of this old grant and has further given it to its officer, the original old grantee will be compensated in perpetuity. Or whether under the 1812 and 1828 Governor General order, these grants were resumed. So there's a lot of things to be seen within the cantonment before giving to these grants. So what did the Government of India, Governor General in Council on record say? By giving a lot of careful attention, the decision which comes in 1860 by Lord Canning, that through Jagirdars might very properly be invited to accept the rule of privileges. Now what does this mean? Accept that these old grants and finally they've flown into the hands of the British officers remain old grants, but whether you are being compensated or not is a question mark. That the government, when granting or confirming an assignment of any revenue, possesses an absolute power of regulating the succession at the time of such grant or confirmation. It is undoubted, but when once the condition of grant has been prescribed and the grant has actually been made, this absolute power is lost by the government. This is well recognized rule of English law for governing of grants from the Crown and is founded on a principle of equity and common justice. So let's say if we were grant given under 1836, now the government has lost all its power on us. So there is no doubt that there exists a distinction between now an estate in land and an assignment on land revenue. These are two different things. It says estate is a land, is a piece of, estate could be a full village or could be 18 villages. I was reading a judgment where it came down that the estate was of some more than 18 villages in Hyderabad. But taking an assignment of land revenue as analogous to a pension, the state of the principles of English law has no inherent right to regulate at or vary at its pleasure. After the assignment or the pension has been granted, the order of succession in either of the one case or other case. So again, the British are very rightfully accepting that once if a grant, old grant is converted into a new grant, so all powers of the state are finished. They are governed by the English principal laws. So what are those laws? Those are normal, whatever acts were going during those periods in the British era. If the Governor General's Council is not satisfied with such powers, it is assumed that they would meet with the hearty approval of Jagirdars and nothing more. So what was the approval? That let's accept them as old grants, and they were revenue free grants, further given to subletted to people up there. So this topic and this word grant, old grant, you know, it's been so much cobwebbed by the Britishers, because all the royal grants which came in the hands in 1795 were revenue free grants, and only the produce was coming through. And Britishers were not interested in 1830s and all, where I had given you those parliamentary documents, that they wanted some kind of revenue on these lands. So that is why this cobweb is so cobbed. It's very, very difficult to peel into it. So once again I am saying, just stick to two things. We were old grants, we were revenue free grants, never ever converted into the new grants, which the Britishers had to do by the Governor General orders. Neither we were resumed by the 1812 or 1822 Resumption GGO. So what are we? Guys, we are proprietors. We are owners of these bungalows, of these OGBs, which the army addresses us. And this is where I culminate to these series of old grant. I would expect and I respect my people who watch me. Please get in touch with me. Understand these videos. Try and tell them to your legal luminaries sitting in your cantonments. I need everybody to get educated so that we can build up our cases in the coming years and we make sure we don't lose any of the cases. Thank you. Good day.